And we are live. Good afternoon, whoever is here. Good morning, good afternoon, whatever. Hello, StreamYard, Born Free Films, Market Watcher, Gator Boy, and whoever else joins us at whatever time. Hello, everybody. Hope everybody's well. I'm in a little bit of a pissy mood today, just to let you know. I think it's unrelated to this, but I am pissy. So if I come across a little bit with a little bit of an edge or more of an edge, that's the reason. But I hope everybody else is well. Hey, Lee, how are you? Hope everybody else is well. I'm just following through with what I promised to do. Hi, Renee. Following through what I promised to do, just to keep everybody apprised regularly, so nobody can be in the dark, or nobody should be in the dark, and everybody should know what's going on. Just as kind of a side issue, I'm just throwing this out here because I've been thinking about this. I'm not a big fan of big government. I'm not a big fan of censorship. And I'm not a big fan of politicians, period. Across the board, both sides, no exceptions, period. Before I get into what I was going to talk about, I haven't seen, so last time I saw was Forster posted something about a week ago that he hadn't had any contact with the receiver. Since then, I'm not aware of anything else that he's posted where he said he had contact with the receiver with regard to the transaction side of the matter. So as of now, I don't believe they've spoken, if the posts were correct, for, maybe a couple of weeks, unless they have and they're just keeping it quiet. But that's not really a good thing, in my opinion. It doesn't necessarily relate to what I'm talking about tonight, but that's the flip side of it. That's the side about by getting a transaction done. And part of that also is, I don't know how anybody could do a transaction without an audit being done, but it's not my call, and I'm just throwing this out there. Before I start, even though I'm really pissy, before I start, I parked my car, and remember what I said, I'm anti-politician, both sides, almost like 100%, very few exceptions, and I have specific ones I despise on both sides, but I won't have to talk about that today. I parked my car right in front of Congress. A cop said, "You can't park there." I said, "Don't worry, I locked my car." What do you call a politician with half a brain? Gifted. Isn't that a sweet little statement by me? I'm really giving props to the politicians there. I'm so pissed off, I got arrested for impersonating a politician. I was just doing nothing. And last but not least, although again, I've restructured this so you'll get two fantastic jokes at the end. Although this one is funny, I just can't figure it out, but I thought it was funny. I'll let you try to think about this for a while. Why do politicians wear neckties? To keep their foreskins from flopping over their heads. I'll let you think about that one for a while. So kind of what I wanted to talk about, besides what I just talked about not liking big government, really, period, and not liking politicians, as evidenced by the jokes. A few things I wanted to talk about. So one thing is, and I've seen it referenced, apparently the administration, this is one of the moves I detest. The administration, as referenced, because this is what Paul Atkins referenced. Paul Atkins, new head of the SEC. The administration referenced that they want to go from quarterly reporting to reporting every 6 months. Makes zero sense to me. And somebody who responded to one of my tweets said, it's more important about getting it accurate, and accuracy is important. What does that mean? Why shouldn't all reporting be accurate, whether it's 3 months, 2 months, or 1 month? We don't need less information. We don't need less transparency. When I heard Atkins describe it, I thought it was full of shit, honestly, and he was completely had no logic to his position. There is no universe, there's no planet where getting reports less often makes us better off. There is no planet. And the purpose of having a auditor is not just to get the information, it provides insurance. So if the auditor screws up, they are carrying insurance. And if somebody needs to pursue them because, for example, shareholders got screwed, there's a pot. And if they don't have to report as often, there's less chance that pot will be available. So it makes no sense, zero sense to me. I think it's counterproductive. It's against the interests of all shareholders, all retail, makes zero sense. All it does is it might lower the cost for some companies for their operations because they have less accounting fees, but it certainly doesn't work for the benefit of shareholders. And there's no logic that makes that clear, because the fact that the auditors suck does not excuse the timing of the audits. Just get better auditors. And if they aren't good, go after them. And that occurred in GTII, by the way. If you recall, after Borgers got canned, Borgers was another auditor that sucked, that basically had to close down because the SEC shut him down. They went to a new auditor, and this was old management and old counsel who I had a scrape with. And after the receiver came on board, if you recall, he talked about his relationship with this new auditor that was based from prior management, and he basically said they screwed us, the new accountant. They wouldn't give him information. They wouldn't carry out their duty. So what did the receiver do about it? Nothing, as far as I could tell. Switched auditors, but pursued no action against the accountants. Why not sue the accountants? They have insurance. I don't understand. Every time somebody does something improper, there was a law firm that was representing the company through the prior management. Apparently, they had to give back their legal fees. Was there any discussion about pursuing them for the claims? But there was no discussion and no reasoning for not pursuing the auditors that prior management selected, that the receiver says was non-cooperative to current management, current receiver. There's no reason not to pursue that. They have insurance, can be done on a contingency basis. In other words, lawyers who take that kind of case, they take a percentage. So there's no cost to the estate other than a percentage. So I don't understand why that's the kind of thing they didn't pursue. And again, that's just an example of why those firms are continuing to be incompetent. If nobody holds them to the fire, especially if, again, the report said, the report of the receiver was not unequivocal in terms of not knowing which way it went. It was clear that they were not carrying out their duties, as that's the receiver's language. No explanation why they didn't pursue it. Zero. So I don't understand that, but the bottom line is reporting should be quarterly, if not more, and there should be no reason they can't get it done. It's all electronic anyway. It's just collecting numbers. It's not complicated. Maybe like drafting the interpretations and the reports is more complicated, but I was not impressed. So we talked about the reporting. We talked about trading, and one of the reasons the auditor, and again, I saw this on X, and that's why I'm addressing it. One of the positions that the receiver is taking, or receiver's counsel, is they can't release certain information, which I think is the transparency that we need, because it's non-public information and people are trading. And so, just to be upfront, I took the position, and I've asked multiple times, I thought the most fair way to proceed would be to stop all trading. And how could you do that? So you could certainly stop all trading in the US. You could at least seek to stop all trading in the US. And to the extent there's trading outside the US, I don't think there's a lot of shares being traded, but I understand there's shares being traded in Canada. So certainly the receiver could contact the SEC in Canada and ask that they stop the trading of the shares or wherever else it's being traded. But if they haven't tried, apparently. How do I know they haven't tried? Because it's not referenced anywhere in the reports. So if it was attempted, it probably should have been referenced in the reports, the 4 reports that the receiver purportedly prepared, although we know that at least one was prepared by the receiver's counsel. But if in fact they sought the cessation of trading, which I think is the fairest way, so there's zero trading, zero. But I haven't seen any reference to it, and certainly hasn't told me anything. And I reached out to the Receivers Council a couple times this week. Haven't heard back, of course. Haven't heard back in a long time. Generally, that's just kind of, they're not willing to respond to me. What happens is they respond to somebody else. That somebody else then forwards me their email, and then I do it. I do a live stream. It's kind of how this works. And they know by now that's how it works. And I should say hello to anybody of former management of GTII who happens to be watching, because from Mr. Benintendo's deposition, I gather that there are. And to any other counsel out there who are watching, please comment, like, and subscribe, please. That would be appreciated. If you're going to spend the time enjoying these jokes, then please like and subscribe. Anyway, so I got contacted by a shareholder this week, and he had basically, and I'm gonna read the response, but I'm gonna kind of generally summarize the question and then kind of explain something so that everybody's clear. So the basic question is, one investor mentioned you on a YouTube that that he had either met you or spoken to you, and the suggestion was the company didn't have enough money to go after Reichman as necessary. And that's the basis of the question, I guess. And then the other part was that the receiver hadn't been in contact with anybody, investors, since July. True or not true, I don't know. Specifically, I think there was emails that were given. So the question is asking about, litigation. And the response is this, and then I'm going to explain the response, and I'm going to nitpick a little bit about the response, as I do. The investor on YouTube, and I don't know if that's me or if somebody else. So this is coming from an attorney, one of the attorneys for the receiver to an investor. It wasn't coming to me, but it's referring to an investor on YouTube. So who's the investor on YouTube? It could be me, I guess. So I'm going to read it again. The investor on YouTube, if I know who you're talking about, and I were talking about the realities of litigation. Now, I don't remember. If it's me, I don't remember that discussion. I've done litigation, so I'm aware of the issues, but I'm not aware. I don't recall that specific discussion, as he's characterized it here. So I don't know if it was a discussion with some other YouTuber who promotes GTII or whose subject matter is GTII or whatever. But I'm presuming it's me, but I don't know. So continuing on, if prolonged litigation would prevent moving the business forward, then the cost of that litigation would exceed the value that could be recovered. We would effectively be litigating to pay attorneys, which is not the goal. As such, there may be reasons to settle with defendants and give something up. If this were a company with robust operations that could afford lengthy litigation, then the cost-benefit analysis switches. So there were general discussions as to the plates being spun and the competing interests. Now, perhaps I had that discussion with them to that detail, but I don't recall it. Obviously I'm aware of costs. So here's the spin on this. So he's talking about the costs in a lawsuit. Now let's divide this case up so we understand there's no confusion. This case really is two parts or three parts. One, freezing the stock. That has been frozen. Two is litigation with regard to this disputed shares. That is ongoing, and that'll be resolved, I presume, within the next 90 days. And then three is a lawsuit against the former officers and directors for damages for breach of fiduciary duty, fraud, or whatever the claims might be. So that's three different aspects. The way this response is provided, it sounds like it's all in one, and it's not. So, and just to prove it, the deposition of Frank Benintendo was not on claims. It was merely investigating the share issue. That's what it was really designed for. I think it was even referenced during the deposition. And if David Reichman's deposition were taken, for example, that would just be, at this point in time, would be on the share issue. And in fact, I think it would be a great idea to take the deposition of Reichman on the share issue. And it might be the case that they're waiting for Reichman to file his, I guess, opposition to the attempt by the receiver to cancel his shares. And in that, there may be declarations, which are, or affidavits, which are statements under penalty of perjury. And they might be waiting to receive those before they take his deposition. But I think they should schedule his deposition now to make sure it occurs before any hearing on the claims. And I don't think they should be. So let me respond to the language. So they're basically saying, there might be times to offer a deal to somebody because you don't have enough cash. So first thing I would say is, should you really be offering shares or a dollar back to somebody until you know what the audit says? Because let's say you're approaching, and I'm just making up things here. Let's say you're approaching Reichman and you think, you know the situation is as we know now. And perhaps you decide, okay, so he has control over 100 million shares. So, and I'm just making up, these are just made up numbers. So perhaps he has 100 million shares. So he'll agree to return all those shares if he gets 5 million shares. So would that be a bad deal? I would certainly consider that if I was counsel, but it goes beyond that. They're saying that they don't want to, and why they're saying this publicly so that the other side knows this too, I don't really think that's wise. I think that this strategy should not have been communicated to shareholders. It wasn't communicated to me. But why would you again indicate that there was an issue about the cash of the company? Why would you let the other side know that? But be that as it may, I think they certainly can litigate the claims part by deposing whomever, and by deposing David again, the impact might be amazing. What might come out of that for various reasons. And the same with Justine Reichman. No reason not to depose those people. And again, here they're kind of giving you the idea that we can't litigate this entire thing because it's a whole case. Let's start off with the shares. Let's get to litigate the shares. If you only want to do discovery as to the shares, let's do that. And if you want to talk about a deal, how about they return, and I'm just throwing out this as a deal. Doesn't necessarily have to be this deal. But how about if you give back all your shares in return, we'll give you a dismissal. So we won't pursue you for all the other damage claims. The only thing, we're seeking the return of, just so we're clear here, we're not just seeking the return of the shares. There's also a damage claim. Now, whether the recover damages is another story, but they would have to defend against, they being all the officers and directors who don't have insurance, they would have to defend against that and pay legal fees, hire attorneys. Reichman, I think, just borrowed 20 grand. We know that. So how much extra money can he have for attorney's fees? So why, with that, why wouldn't you press? Why wouldn't you press based upon all the receivers' reports? Why would you crush them on the share portion of this based upon the receiver's report? It makes no sense. We're already here. It doesn't require a huge expenditure of fees to litigate the claim portion. And by litigating the claim portion, it might litigate the entirety of it just based upon the testimony. So this language I thought was a little bit deceptive because it suggests it's talking about the whole case, not the share count. There's no reason. I don't think there's any good reason not to pursue the retention of all those shares until the final audit is received and we could figure out who's responsible for what. Because again, like I said, what happens if the receiver thinks, and I'm just making up numbers again, what happens if the receiver thinks that Reichman stole 100 million shares and the audit shows that he stole 200 million shares? Isn't that something you'd like to know before you made a deal? And that's why we've been pushing about getting the audit done. And that's why I'm pissed and annoyed that we get no feedback on that and nothing, zero, because the Receivers Council takes the position that it's non-public information because it's trading, even though I asked them to make it not trade. And apparently, again, they haven't done anything to try that. So they've elected the least, the road that's the easiest to travel with the least resistance, that doesn't provide us the most transparency. But it's an election they have because they've decided they don't want to try, and this is months ago, by the way. It's recent, it's months ago. They've elected not to try to shut down all trading so everybody's in the same position and nobody can take advantage of anybody, and no shorts can escape to the extent they're shorts. But for whatever reason, it's not referenced in the report. So if they've tried, they haven't referenced in the reports, but they've done nothing. So I just wanted to talk about that one issue, the issue about the litigation issue, since this was sent out on Wednesday of this week, and that it's certainly clear to me that you could litigate the claims portion. You could depose the people I've mentioned. You could depose Reichman, Griffin, and Reichman, and let the chips fall and just do it on the shares, and let's see what they testify. Let's see if they testify. No reason otherwise not to do it. None. This is not going to the end of the case. This is now. And again, I would request the Receivers Council not to send emails to anyone that reference, unless it's attorney-client privilege, that reference that there's not a sufficient amount of money to pursue claims against the other side. I just think that's a silly reference. I also don't think it's true to the extent we need it. It certainly seems to be enough wherewithal to do what we need on the claims portion. Anyway, so that's all I have to say. This was an email from this week. If you want to communicate your own position to the receiver, please do so. The three things we talked about were, I was pissed about many things today, but we talked about the reporting and that I'm opposed to making the reporting from 3 months to 6 months. I don't see how it benefits shareholders, retail in any way. It doesn't excuse the auditors. They should be held accountable anyway. That was a problem of GTII. And if there's action that can be held, all those auditors have insurance. That's an extra round of protection for shareholders. That's why we want the auditors involved, because it provides a cushion for everybody. Two, I've asked for a trading cessation of GTII period multiple times, because I want full transparency, because the rationale reason why a lot of items are not disclosed by the Receivers Council is he claims they're non-public information. There's trading and they can't do it. I've asked multiple times for them to stop the trading so all that non-public information can be disclosed and we all would know. I've not seen any reference to it in any report or any email or anything like that. So I presume they never tried. And I don't know why. Maybe they don't have the expertise to do it. I don't really know. They certainly could have found somebody to probably do that, but I don't know. I really don't know. And last but not least was the email to a shareholder today or this week that referenced that the cost of litigation was too much or was referencing a prior discussion with a shareholder, which seems like it was me, apparently, where the reference was that, you have to balance cost versus benefit in litigation, which is 100% true, by the way. But it doesn't reference that the claim is a separate part of the litigation that doesn't require full-blown efforts, and that you could trade a dismissal of future claims and keep shares. In other words, you could, if someone's willing to give back their shares and in return just wants a release of all claims, I have nothing against that. So I really don't understand the rationale, because certainly the claims part can be handled. Discovery can go through that. There's no reason not to do it. In my opinion, no reason. That's my view of the world. All right. And on the way out, I have two for you. Let's see how these two go, if they can be possibly as good as the first four. What's the difference between a flying, and you have to listen very carefully here. What's the difference between a flying pig and a politician? The F. Think about that one. And last but not least, politicians are like sperm. 1 in a million turn into a human being. And with that, I will leave you for the weekend. I hope everybody is well. Be well. Obviously, if I find out anything new, if I get any new emails, if I hear from anybody who has information, if I hear from the receiver, if I hear from the receiver's counsel over the weekend, and I'm waiting with bated breath, then I will certainly let you know, and I will obviously keep you apprised of anything that goes on. With that, I will say good afternoon or good night. And for everybody out there, be well and have a great evening and take care of yourselves. All right. Be well.